So on to today's session, which is entitled Retail Insolvency Insights. My name is Elaine Peterson, and I'm a partner within the real estate team here at Brodie's. I regularly act for landlords of retail assets, and I've got particular experience advising on the property-related issues which can arise as a result of insolvency. I'm delighted to be joined today by my fellow partner from our restructuring and insolvency team, Lucy McCann. Lucy has vast experience advising on all aspects of corporate and personal insolvency, so she's got a real first-hand insight into what the restructuring community has seen so far as businesses try their best to adapt to cope with the financial implications of COVID-19. With the Scottish Government confirming at the end of last week that there would be, at this time, no easing of the current lockdown restrictions other than in relation to outdoor exercise, the economic impact of COVID-19 is being felt heavily across Scotland's high street, with many retailers expressing concerns that the likelihood of doors reopening is significantly reducing the longer that lockdown continues. As a result, the restructuring and insolvency profession is predicting a wave of retail insolvencies. In this half-hour session today, we thought it would be useful to consider what that phase of restructuring may look like for retailers and the impact which that will have on landlords operating within the sector. So moving on to our first slide, I'm going to pass you over to Lucy, who is going to outline the key preliminary questions which will be relevant for any insolvency.
Thanks, Elaine. Good morning, everybody. So, insolvency, what does it mean? Insolvency itself is not a term of art. In its true sense, it simply means being unable to pay the debts that you owe. And when companies or individuals are unable to pay the sums they owe, there are legal processes which the entity can go through and which are designed to ingather assets with a view to making distributions to their creditors. There are a range of procedures which are designed to achieve this distribution. In today's seminar, we're going to be focusing on the two corporate regimes which have been most prevalent in the retail sector and which you will have come across, namely administration and company voluntary arrangements. So let's take a whistle-stop tour of those particular regimes, starting off with administration. Administration in the form we now know it was introduced by the Enterprise Act and came into effect in 2003. It was designed to promote a rescue culture in the UK for businesses in financial distress. On the appointment of an administrator, the directors are divested of their management powers, and it's the responsibility of the administrator to take control of the affairs of the company, ingather assets and make a distribution to creditors. What you'll hear people talking about is the purpose or the objective of administration. What they're referring to is the hierarchy that's set out in statute, which in order is that you have to rescue the company as a going concern, and if you can't achieve that, then you have to achieve a better result for creditors than a winding up. And if that can't be achieved, then you have to realise property with a view to making a distribution to the secured and preferential creditors. An administrator must perform his duty in accordance with that statutory objective, which is selected at the outset of the process and is approved by creditors. Administration as a process is often seen as rehab. You go in, get fixed up, and you head back out and get on with your life. The way in which the regime helps the company to get back on its feet is by giving the company breathing space and crucial protection from its creditors. That protection is called a moratorium, and I'll pick up on that moratorium again in just a few minutes. CVAs, company voluntary arrangements. When you look at the restructuring toolkit available, CVAs have been the tool of choice in the retail sector, and many of you will know your way around these pretty well. CVAs are designed to allow companies to enter into compromise agreements with their creditors, either all of them or just certain classes of them, with a view to repaying a proportion of the debt owed over a period of time. And if successful, they receive debt forgiveness from their creditors. CVAs are monitored by supervisors, and the day-to-day management of the company remains with the directors, and the supervisor takes quite a hands-off approach. To be approved, the CVA has to get support for 75% in value of creditors who are entitled to vote. Again, these are things you'll all be familiar with. And if the CVA is approved, then creditors are prevented by the terms of the CVA from being able to take action against the company in respect of the CVA debts. The drafting of CVAs have become much more sophisticated over the years, so that in many cases a company can get that protection for creditors even before the CVA is approved. And again, no doubt many of you will have seen that in operation. As Elaine and I will explain, we see the use of CVAs in the retail sector decreasing in the coming months, but we'll discuss our rationale for that a little bit later on. So why does any of this really matter? It boils down to the fact that if you know a little bit about the regime that the company is in that you're dealing with, then it'll help inform you in the strategy that you wish to adopt. And it'll also direct you as to who the appropriate person is making decisions, what motivates them, and the conversations you should be having. When dealing with administration, you want to be dealing with the administrator. And when you're dealing with CVA, you're going to be dealing with the company management. So moratorium, touched on this just a moment ago. What is the moratorium? In this section, what we're going to be discussing is concentrating on is the statutory moratorium available under paragraph 43 of Schedule B1 to the Insolvency Act. And this is the most powerful protection available to companies. What do I mean when I say it's powerful? I mean it prevents action from being raised against the company. It prevents landlords from being able to irritate or forfeit leases. It prevents goods on hire purchase being seized, all unless you have either the consent of the administrator or the leave of the court. What the moratorium does is allow the company and administration to interfere with a third party's proprietary rights. So if, for example, the administrator refuses to allow a landlord to irritate a lease, the court would not automatically grant permission for the landlord to do so. Instead, what happens is the court would be carrying out a very careful balancing exercise to see how the granting of that right to irritate would impact on the administrator's ability to achieve the statutory purpose of administration. And if the court thinks that it would not be in the best interest of creditors to do so, then they will not grant the order. Now, if you're the landlord, obviously, in that situation, you could see that there would be an element of unfairness, and there could be a perceived unfair result. Elaine's going to now look at some of the effects of tenant insolvency.
Thanks, Lucy. So moving on to our next slide, which looks at the effect which tenant insolvency has on a retail landlord. With the number of retailers expressing concerns as to cash flow predictions, retail landlords are looking at their own tenant profiles to consider what effect tenant insolvency would have on their assets. The first question which a retail landlord is likely to ask is what happens to the lease if my tenant becomes insolvent? In England, a liquidator has the right to disclaim a lease, but this is not a statutory power which is possible in Scotland. Although an administrator in Scotland does not have the power to automatically terminate a lease, they can decline to perform the tenant's obligations if they consider that it's in the best interest of the creditors to do so. So that means that the landlord would need to apply to the court to order that the tenant's obligations under the lease are performed, and that will only happen in exceptional circumstances, as the court requires to balance the competing interests of the landlord with the objectives of the insolvency process. So on the basis that the lease is continuing, the key consideration for a landlord is how does that affect the income stream derived from the property? Whether or not the landlord is able to recover any payments due under the lease will depend on two things. The first is the period to which the payments relate to, and the second is whether or not the property has actually been occupied during this period. At the point when the administrator is appointed, a line in the sand is drawn, so there is an important distinction between arrears which accrued pre-appointment and those which accrued after the date of appointment. For any arrears which relate to the period prior to the tenant entering into administration, the landlord will only rank as an unsecured creditor, which means that they will only receive the sums due if there's any money left in the pot once all other liabilities have been paid. However, if actual physical occupation of the property by the tenant continues after the appointment of the administrator, then the payments due for this period are recoverable as an expense of the administration, which falls within the brackets of the first set of payments to be distributed. But this right of the landlord to receive lease payments as an expense of the administration will only last for as long as the premises remain actually occupied by the administrators, and it will accrue on a daily basis throughout occupation. This principle was set out in a case which related to the administration of the retailer game, and it specifically dealt with rent, but it's generally accepted that the same principle would apply to other payments such as service charge. If the administrator is not continuing to occupy the property, that doesn't bring an end to the tenant's liability to pay the rent, but the rent would again just be an unsecured claim in the administration. Depending on the property, the landlord may be quite happy to let the lease continue even where the administrator is not actually occupying the unit, as termination of the lease could potentially trigger other liabilities such as utilities or where protections aren't in place, rates. However, if the landlord does have another tenant lined up, or if it's just preferential to take the unit back for some other purpose, then the landlord will need to consider whether it will be possible to actually recover the premises from the administrator. When a tenant goes into administration, they will have the benefit of the moratorium, which, as Lucy mentioned, provides this powerful protection to the company, which would prevent the landlord from irritating the lease without either the consent of the administrators or the court. However, if the landlord does want to take the property back, then the first step should always be to speak with the administrators, as if they're not expecting to be able to assign the lease to generate some form of income, and they're not using the property for the purpose of the administration, then it is possible that they may be happy to voluntarily agree to a surrender, which is always going to be preferable for a landlord than any formal litigation procedure from both a time and cost perspective. Given the protection which a tenant in administration receives via the moratorium, it's quite understandable that landlords can feel like they have limited options available to them when it comes to a tenant insolvency. However, our next slide sets out some points which are always worth a landlord taking into consideration. A landlord will always want to check if there are any rent deposits held, which they can take towards the sums owed by the tenant. Whether a rent deposit will be available is going to depend on the terms of the rent deposit agreement and how the funds are being held, as these could potentially be considered to be property of the insolvent tenant. So advice should always be taken on the terms of the rent deposit agreement and whether or not the landlord is able to apply these funds. When considering rent deposits, it's just worth mentioning a case which it's an English case, but it was at the end of last year, which acts as a bit of a cautionary tale to landlords to ensure that they do take legal advice on how any rent deposits held should be applied. In this case, the landlord used the rent deposit monies to pay rent owed by the administrator for the period of their occupation, and then looked for the administrators to top up the balance of the rent deposit. However, the judgment stated that there was never any dispute that the administrators were obliged to pay rent for the period during which they had used the property, and that would have been payable as an expense of the administration. So essentially, the landlord had elected to use the rent deposit monies to settle those arrears where they had been under no obligation to do so, and what the landlord should have actually done was use the rent deposit towards other sums due under the lease. This case just flags the pitfalls which a landlord can easily fall into when it comes to rent deposits and tenant administration, and it is always worth taking advice as early as possible to ensure that the landlord is maximising any recovery which they may have. Due to their nature, recovering the cost of dilapidations poses difficulty in an administration context. Where an administrator is using the property for the benefit of the administration, then you would think that if a dilapidations liability were to arise relating to that period, then it should be possible to recover that as an expense of the administration. However, the difficulty is that it's much less likely to be clear at exactly what point a dilapidations liability actually becomes due, compared to other payments such as rent and service charge, which we all know has a designated due date and relates to a specified period. Also, to make administrators responsible for the breach of any pre-appointment lease obligations would be contradictory to the administration process, which, as Lucy's highlighted, is very much to protect the company and allow breathing space for recovery. However, the position is not wholly definitive, so a landlord should not just automatically assume that dilapidations will not be recoverable. Where the administrators are occupying the property and there could potentially be value in a dilapidations claim, it's always worth a landlord considering whether they should obtain a schedule of condition as soon as possible following the appointment of the administrators, so that they can maximise any ability which they may have of recovering any dilapidations which do relate to the period of the administrator's occupation. Whether there'll be any merit in this from the landlord's perspective will obviously depend on the nature of the property and the potential sums involved, but it is always worth giving consideration to this. Also, in the recent case I mentioned, which related to the rent deposit, it was acknowledged in the judgment that if the landlord had left the rent deposit untouched in relation to the unpaid rent by the administrator, then the landlord would have retained security for other payments under the lease, which may have included dilapidations. So that would have ultimately improved their overall position, and it acts as a clear reminder that it's always better to review the landlord's position as a whole under the lease when trying to maximise recovery, rather than looking at individual elements in isolation. A unique aspect of Scots law is the landlord's right of hypothec, which is a common right of security enjoyed by landlords over goods owned by the tenant within the leased premises to the value of the unpaid rent. Landlord's hypothec is a preference on insolvency, which relates to the movables owned by the tenant, and it only relates to rent and only for so long as the rent remains unpaid. Given these days equipment or goods within properties may not be fully owned by tenants, landlord's hypothec may have limited value, but it is always worth considering, and as it's unique to Scotland, in certain circumstances it can be a bit of a surprise bonus in terms of the toolkit available to a Scottish landlord. So where are we at present? Well, if we move on to our next slide, we can see that the UK and Scottish governments have announced a series of financial support packages to protect businesses from the immediate impact of COVID-19. I expect most of us are now probably relatively familiar with what is in place at the moment, but a brief recap on the current measures. So at the moment, we've got protection from eviction for commercial tenants. So in Scotland, landlords must give commercial tenants 14 weeks notice before they can evict them for non-payment of rent or any other payments due under the lease. Any 14-day notices served requiring payment which had not expired as at 7th April 2020, which is the date that the Coronavirus Scotland Act came into force, are void. In England, no business tenants may be evicted if they miss a rental payment between the 26th of March and 30th June 2020, and a rental payment will include any other sums due to be paid by the tenants. So although the protections are similar north and south of the border, it is worth noting that neither amounts to a rent holiday. So that means from a tenant's perspective, unless that's specifically agreed with a landlord, the debt is not actually going anywhere, but rather being kicked further down the road. Both the UK and Scottish governments have introduced versions of the Retail and Hospitality Grant Scheme, which provides businesses having a rateable value of less than 51k the opportunity to receive grants. In both Scotland and England, there's an automatic 100% rates relief for the 2020 to 21 tax year for retail, hospitality and leisure businesses. The properties must be occupied, but temporary closure to deal with COVID-19 doesn't mean that the property is deemed unoccupied. And in Scotland, there's also a reversal of the 1.6% rates increase for all non-domestic properties for the 2020 to 21 tax year. Both the UK and Scottish governments have introduced planning relaxations, which means that enforcement action can't be taken against pubs, restaurants and cafes where they've converted their businesses to hot food takeaway. This will last for 1 year in England and so far in Scotland until June 2020, but that may be reviewed. There's obviously the UK-wide Coronavirus Business Interruption Loan Scheme, which is offering support to UK-based businesses with a turnover of up to 45 million, with access to finance up to 5 million for up to 6 years. The government revamped the scheme to make it easier for businesses to access funding, and it also announced 2 further schemes, the Coronavirus Large Business Interruption Loan Scheme and the Bounce Back Loan Scheme. Finally, we've also got VAT deferral, so all VAT registered UK businesses may defer payment of VAT due to be paid with VAT returns for the period between 20th March to 30th June 2020. So they have until the end of the 2020 to 21 tax year to pay any VAT which became due during the deferral period. However, in addition to these measures, what is currently still awaited from the government is the Corporate Insolvency and Governance Bill, which is expected to set out specific protections for business from debt recovery to reflect the financial hardship they are facing as a result of COVID-19. So I'm going to pass you back to Lucy, who's going to update us on the latest position and the proposals which are expected to be most relevant for the retail sector.
Thanks, Elaine. So Elaine's told us a little bit about what we know already, so let me tell you a little bit about what we're waiting to hear about. And as Elaine has said, we're waiting with bated breath for the Corporate Insolvency and Governance Bill. This is probably about as exciting as it gets for insolvency lawyers, to be honest with you. But the thing that's really important about this bill is we've got some headlines from government press releases about what is likely to be in it, but we've still not seen the bill yet. We expect it in the next 24, 48 hours. So, and we will be keeping you updated with those and with the measures that are in it. There's ones that you've heard about already and which are probably most relevant are the first three on that list. I'll touch very briefly on the last two, but they're not really relevant for retail landlords, but you might have heard about them, so we want to mention them to you. So protection from stat demands and winding ups. This measure is a direct result of lobbying by the British and Scottish retail consortiums and other stakeholders, and are designed to prevent creditors. All the press talks about landlords from serving stat demands and then proceeding to wind up tenants on the back of those stat demands where they cannot pay as a result of the pandemic. The provision, like all the provisions in this bill, are going to be retroactive, so that once enacted, they'll be enforced from the 1st of March. We've already seen examples of where the English courts have refused to grant winding up orders where a landlord has served a winding up petition based on a stat demand which has not been answered as a result of the tenant having what I will refer to as a COVID-19 defence, i.e. they cannot pay as a result of the pandemic. Now, it's not very clear whether or not these provisions will be enacted in whole or in part in Scotland, but we think that they will apply, and we would expect the Scottish courts to uphold the spirit of the legislation and refuse any winding up orders where a tenant has a COVID-19 defence. Relaxation of wrongful trading. Again, this is another pro-business headline, and it's been brought about through lobbying by the CBI. Wrongful trading is an offence under the Insolvency Act. It applies to directors and former directors of companies that have entered into insolvency proceedings and who have allowed a company to continue to trade where they knew or ought to have been aware that the company could not avoid insolvency proceedings. And where an offence occurs, the corporate veil is essentially pierced and the directors of the company can be held personally liable for the debts or losses which have been accrued during the period of wrongful trading. Appreciate that we are cantering through these measures, but please be very aware that the relaxation of this measure cannot be regarded as a panacea for directors who act in breach of duty. There are serious consequences for breach of duty, and the suspension of wrongful trading does not mean that there aren't other remedies available to people who have been disenfranchised by people who are acting in breach of duty. So the new moratorium, now this is the one I think is probably the most interesting, and it's something we'll touch on what we are predicting is to come. The new moratorium comes from a 2018 consultation and proposes to extend the moratorium that we're talking about that's available in administration to companies. It's not triggered by the appointment of an administrator, but simply by filing an out-of-court appointment form. The moratorium, which will be enacted, is likely to have an initial duration of 28 days, but it will be capable of ongoing extension. We think for up to 6 months, although it might be up to 9 months. And it's likely that the company will be permitted to use that process only once in every 12-month period. And you cannot use it if the company's been insolvent, i.e. has entered into a CVA or been in administration during that same 12-month period. You should think about this a little bit like a CVA, and how it works is that a monitor who's qualified, as a qualified insolvency practitioner, would be brought in to confirm that the company meets the criteria fixed and to monitor the use of the moratorium. The moratorium would come to an end where the monitor concludes that the company does not satisfy the qualifying conditions, or creditors petition the court to say that there has been some unfair prejudice to them as a result of the moratorium being in place. Again, I'm just conscious of the time, so we'll move on past the ipso facto clauses and the cram down measures, because again, they're not necessarily relevant, but something to be aware of. What do we see in the months ahead? And I think this is probably the most interesting thing for you. there's a real danger of always trying to, there's a real danger of trying to predict the future. And what we do know is that lots of businesses in the retail sector were already in trouble, having to deal with high rates and taxes, lower footfall and greater online competition. COVID-19 crisis has simply exacerbated those problems, and with cash running out and limited ability to generate income, businesses will fail. It'll become harder for those who are already in difficulty, and what was meant to be simply temporary interruption is now feeling a lot more permanent. I guess the key to survival for thousands of businesses and jobs will be the extension of the government furlough scheme and all of these protective measures that have been brought in. And it'll take some time for companies to try and get back on their feet. And what they're going to require is the forbearance of their stakeholders and their lenders. The litmus test is really going to be when the trading starts to resume and what levels individual businesses are going to come back at. There have been positive news stories from Primark and from Superdry, who've opened stores in Europe and have been reported encouraging sales. Unfortunately, we don't think that that's going to be reflective of every single business across the market in this sector. So we think that there is going to be a wave of retail insolvencies to come. We don't think that there's going to be that many CVAs. They're not going to be the tool of choice. Instead, what we think will happen is there'll be perhaps more light touch administrations, which you're seeing in Debenhams, where, for example, the administrator is appointed and then they delegate the day-to-day management power back to the company directors. We don't believe, though, that light touch administration is going to again be this tool of choice, and the reason for that is they're expensive to run, and Debenhams is a bit of a novelty because its board is really filled with turnaround specialists, so the administrators themselves trust that board. Instead, what we think is going to happen is that companies really will take advantage of this new corporate moratorium, and they'll buy themselves that 3 to 6 months breathing space while they try to get back on their feet and ascertain how the trading pattern returns. This will be a cost-effective process and will give the company access to this all-powerful moratorium. So in terms of our predictions, that's what we think we will see more of in the retail sector. Elaine, I'm conscious of our time here. Have we got any questions at all?
We do. Thank you, everybody, for all the questions that have been sent in. It's great to see the issues that people have been considering. Just on the moratorium, Lucy, actually, we've had an interesting question about whether the moratorium would apply to all types of lease agreements, so not necessarily just your kind of formal lease if you had licenses or other concession agreements. But really, the point with the moratorium is it protects the company. So anything which is a contract that the company has entered into gets that protection. Would you say that's a fair assessment, Lucy?
Yes, no, I think that's absolutely right. I think that you have to think about what the moratorium is actually designed to do, and it is to try and give that protection to the company. So if it's the case that the landlord is trying to interfere with, for example, or terminate a license agreement, then yes, I think the moratorium would protect in those circumstances.
Thanks, Lucy. And then maybe just room for just another one. Someone has asked in relation to the Debenhams one and this concept of light touch administration. So does that mean that landlords can just agree with the existing contacts that they have, the asset managers? Do they need to worry about the administrators?
Yeah, so this is quite an interesting one, and what the administrators of Debenhams are saying is that practitioners and stakeholders all need to be re-educated, and we need to understand that we have to deal with our day-to-day contacts. So absolutely, as you say, the guys on the ground that you're normally speaking to. I think from my perspective, if I'm looking for that element of comfort, I want to be speaking to the organ grinder. I want to be speaking to the administrator. But that again is something that makes light touch administration perhaps not the ideal restructuring tool, because it adds cost and expense and delay into the process.
Okay, I think that's probably, I don't want to keep people beyond the allotted time, but thank you to everyone who submitted a question, and if you've provided your details, then we'll follow up with you afterwards in terms of kind of our thoughts and comments on any questions you've asked.
Thank you. So I guess that's just for us to say thank you very much for attending today, and we hope that you have found the session of interest. And as Elaine says, we will be following up with questions that have been left. But if you do have any queries, then please do get in contact with us. You've got our contact details there. Thank you.
Thank you.